Okay, so I am going to get started. First of all, I'm Scott Silberman, and this is a first in a series of webinars that my office and I will be doing for our clients and for others who want to attend. For those that don't know, our office, Silberman Lam, we represent injured workers before the Workers' Compensation Appeals Board. And I do see a vast array of people have registered to watch today. Everything from our clients and other injured workers, as well as we have defense attorneys, we have auditors from the Department of Insurance, doctors, and others that have also registered. So I would like to state the information I'm giving is mainly information I think that's most important for our clients who are injured workers. But of course, everyone else is welcome to attend, and I will try to address other questions at the end if you have questions that maybe are geared more towards a doctor or a defense attorney or something like that. And again, I'd like to tell everybody, if you have questions, to use the Q&A button. Feel free to go and ask any questions. I will try to address them all at the end, and maybe some of them as we go, depending on how this goes. All right, so hopefully you can all see my screen okay. So the title of today, I've titled it UR and IMR, How Does the System Work? All right, so the first thing is, what is utilization review and independent medical review? And that's what these terms are, UR and IMR. And I know a lot of times our clients call up, they'll talk to me, another attorney, or a paralegal, and we use a lot of acronyms. So the two acronyms we're going to be talking about today are UR, which stands for Utilization Review, and IMR, which stands for Independent Medical Review. So utilization review is the first step in the insurance company's review of requested medical treatment. Now, this utilization review is done in-house by the insurance company or by a utilization review company that's hired by the insurance company. So one misconception a lot of times we get from our own clients is when people say, the adjuster denied my treatment. Okay, if you got a utilization review denial, you'll notice the adjuster's name is not the person who signed that. It'll be signed, if it's a denial, it'll be signed by both a nurse and a doctor. If it is an approval, it can just be signed by a nurse, or also sometimes by a nurse and a doctor. Now, an adjuster can authorize treatment without sending it to utilization review, but they cannot deny treatment without sending it to utilization review. And it is rare that an adjuster will authorize treatment without sending it to utilization review. Now, independent medical review is the step after utilization review, and is done by a company called Maximus that's contracted with the State of California Division of Workers' Compensation. So the insurance company does not get to choose which IMR company they will use. Everybody uses the same. It's Maximus. So when you get a denial from independent medical review denying treatment, it's not the adjuster who's denying the treatment. It's Maximus who's denying that treatment. Okay, so the first step, as we just covered, was utilization review. And the question is, how does utilization review work? What is utilization review? So the first thing is, how do we get there? So in order to get to this step, your doctor needs to complete a request for authorization. Now here's another acronym you'll hear a lot, RFA. So when your doctor tells you, we're going to need to prescribe some medication for you, it's not like when you go to your own HMO doctor and they write the prescription and you go downstairs or across the street and go to the pharmacy and get the medication. While they may hand you your prescription at the time, they also have to fill out a request for authorization or an RFA. Now, if there is no RFA done by your doctor, the defendant is not required to review any request for treatment. Now, the RFA is a particular sheet that's filled out by your doctor, and once the insurance company has the RFA, they're supposed to give this and any accompanying medical reports or documentation that was submitted with the RFA to the utilization review company. Then the treatment can be approved by a nurse or doctor or denied by a doctor. The UR company will usually only consider any medical submitted by the doctor if submitted at the same time as the RFA. Now, this is important because a lot of times we'll get calls from our clients saying, why didn't you send the medical reports to utilization review? Well, we don't. We can't. We can send medical reports, as I'll get to in the next steps, to independent medical review. But utilization review is going to get exactly what the doctor submits. And typically what they submit only with the RFA. So your case may be 10 years old, and you may have already had lumbar epidural injections, physical therapy, and a number of other treatments, but the doctor's requesting surgery. But if all the doctor submits is the request for authorization and doesn't have the documentation attached, like a medical report outlining everything that's been done, that's all utilization review is going to see. Now, the utilization review company is supposed to complete this within 5 business days of the RFA being submitted by fax. And if they don't submit it by fax, but they mail it in, then they get 5 additional days. The insurance company gets 5 additional days for mailing, to wait to get that in the mail. Even if they get it the day after your doctor sends it, they get the extra time for submitting it by mail. Now, this is important, is that the utilization review believes they need more time. They are allowed up to 14 calendar days. So they are, in many cases, allowed up to 2 weeks from the day they submit the request for authorization in order for that treatment to be approved or denied. So it's very important to remember this, because again, we talked earlier about the prescription that your doctor handed to you at the time of the evaluation for the medication that you need. And now that you see this, and of course, we probably told you in the past as well, the insurance company for most of those medications is going to have up to 14 days to fill it from when the doctor hands you the prescription. So why is this important? It's important that you're going and seeing your doctor at least a week, if not 2 weeks, before you need to fill your medication. In most cases, the approvals or denials are done within 7 days, which is 5 business days. But there are times where the insurance company or the utilization review company says they need more information or more time, and that can take up to 14 days. So it's very important for planning purposes. Okay, so I have here some samples of what you may see when you get it in the mail, so you know what it is. So this is a sample of an approval letter. In this case, the injured worker had 5 different medications, and all of them were approved. Request for, and they're each listed here. Request for the different medications. Here we have one called Prestique. I'm not going to try to pronounce all these, but as you can see, there's 5 different, and they all say certified. So certified is a key word on these. Certified means they're approved, and you should be able to go to the pharmacy and pick those up. Okay, so here's another sample approval. So this was an approval. This is the data was received, and this is what they approved. They approved epidural steroid injection. And this is the certification period. So this is also important, especially right now as we're going through this COVID-19 crisis. And a lot of surgeries, treatments, and so forth aren't being done by the doctors. They're only supposed to be doing essential services, no elective surgeries. And as many of you know and are frustrated with, some of these surgeries have been put off. So it's important to look at the certification period. In this case, this one's certified for an entire year. In many cases, they're not done for a year. It could be for 3 months. Okay? In some cases, I've seen them either a month, but most of them are going to be around 3 months. So know when your certification period is. There are instances your doctor can get the certification period extended without putting in a new RFA, especially now in the COVID-19 situation. The doctors can often call and ask for an extension and get those granted. So, but on the other hand, it's not always going to happen. If you are given 1 year to get a lumbar fusion and you decide you want to get it in month 11 and then things come up and now we're outside of the period, there's a good chance that your doctor is going to have to submit another request for authorization. And things may have changed in that last year as far as your treatment and findings that it may no longer be approved. So it's definitely important to watch those. All right, so there's 3 things that can happen to a utilization review. It can be approved, it can be denied, or we can be given a modification. So what's a modification? Well, the most common thing we see for modifications is going to be the quantity. It's going to be the quantity of medication that's dispensed. It's going to be quantity of physical therapy that's approved. That's usually what we see when it's a modification. So in this one, it says UR modified is what I've titled it over here. But where you'll see is my highlighted area over here, where it says 60 Restoril 30 milligrams has been modified to a certification of 30. Okay, so there will be following this, and I didn't put that all in here, but an explanation of why they modified it. So this is something we can appeal, and we do appeal. We do appeal all modifications, and we appeal all denials unless we're told that it's something that you don't want. So if the doctor prescribes surgery, you got a denial and you don't want the surgery, let us know. When you get the denial in the mail, you don't need to let us know. We're automatically appealing all of the UR or utilization review denials. All right, so here is, and modifications as well. Here is an example of a UR denial, and it's also known as non-certified. So you may see that depending on what insurance company is handling your claim, you may see one of 2 things. You may say non-certified or denied. So in this case, it was a lidoderm patch 5%. Then RFA was submitted on 4/13/2020, and it says it was denied by the physician advisor. And there were pages after this explaining why it's denied. But again, I just want to point out to you that this is what a UR denial looks like. All right, so what are our steps after we get a utilization review denial? So in our office, there's 2 things we do. The first thing we do is an internal utilization review appeal. Now, the utilization review companies get to decide if they want to allow internal appeals or not. Most of the utilization review companies do allow for an internal appeal. Now, I noted on here that some utilization review companies, when they devise their own requirements and so forth, they only allow this appeal to come from the PTP. There's a few out there, it's not too many. Most of them do allow either the applicant or the applicant's attorney to do the appeal, and we do an internal utilization review appeal for every denial. Even if they don't allow it, we still do file one. And this is an appeal direct to the utilization review company asking for a second opinion. The second opinion is supposed to go to a different physician in the utilization review company than the first one did. In most cases, given to a different doctor in the same utilization review company. And it can be either approved or denied at this level, meaning that they can overturn the previous denial or they can stay with the previous denial. So here's some examples of what you may see for an internal utilization review appeal. So here's an overturn. Because some people are probably saying, oh, you sent it back to the same company, it's never going to be overturned. I do have a couple of people, it shows that they're raising their hands. If you do want to ask a question, just type the question in the question and answer instead of push the raising your hand button. So in this case, this was overturned. It was actually a lumbar interbody fusion, which is a back surgery, a back fusion that was originally denied by utilization review. We did an appeal, and even before it got to independent medical review, before it got to Maximus, The appeal was already overturned by the physician advisor. So that was a different physician with the same company. And you know, of course, when all these other things will say overturned too, that's because there's a number of things that are usually ordered with the surgery, including physical therapy afterwards, blood work, you know, so forth. So everything was overturned in this case. So this is an example of what you may receive in the mail for an approval, an internal overturn, approval by utilization review. Okay, so often what you get, especially from the utilization review company, is going to be a denial of the appeal. And this one, you'll see here, this was an appeal of an MRI of the left knee, appeal upheld by the physician advisor. So what the appeal upheld means is that it's still denied. So that you got the first letter in the mail that it's denied. Now you got another letter from utilization review. The MRI is still being denied. So what's our next step? So now we've gone to utilization review and your treatment's been denied. We did the internal appeal and that's been denied. So what happens next? So actually at the same time we file the internal utilization review appeal, we file an appeal to independent medical review. Now, independent medical review, or IMR, to use the acronyms we like to use in workers' comp, is an appeal from the utilization review denial to an outside company called Maximus. Now, when the appeal is made to Maximus, the parties get a letter from Maximus. Now, I say the parties, if you're represented, then it'll be your attorney and the insurance company. If you're not represented, then this letter is going directly to you in your mailbox. You get a letter from Maximus acknowledging the receipt of the IMR appeal, and they're requesting for records. So the defense, when I say the defense, I mean the insurance company. In most cases, I would say 99 times out of 100, it's actually the claims adjuster or the insurance company that's going to be sending all this to Maximus and not actually the defense attorney. Now, they are required to submit pertinent medical records, but they're actually only required to send 6 months worth of records. Now, the applicant is able to submit records as they wish. When I say applicant, I mean injured worker or the injured worker's attorney. Now, in our office, it's our policy to submit the entire file to Maximus, whether the case is 3 months old or 20 years old. And I can tell you, when we first started filing these, especially when they were allowing online submission of filing medical records with Maximus, they were calling us and telling us we're only supposed to submit 6 months. And we pointed out to them in the code that that's the minimum to submit. And to make sure that they have all the records necessary, we submit all the records that have been generated in your case. Now, after Maximus reviews the utilization review denial and the medical records, they issue either an uphold or an overturn of the denial. What do those mean? An uphold means they agree with utilization review, that it should be denied. An overturn means that they're going to go ahead and authorize it. When we get an overturn, then the insurance company has 5 days to authorize that treatment from when they receive the overturn. Now, the IMR must be requested within 30 days of the initial utilization review denial. Now, when I say initial utilization review denial, I mean not the appeal. The first time they denied it. Now, the first time they denied it from an RFA. It could be next month a new RFA submitted with a material change of facts, which I'll get to in a little while, and then that starts the process all over again. But we're going to get one IMR for one RFA. All right, so what are the IMR timeframes? So the time frame for the applicant or the applicant attorney to request IMR is 30 days from the date of the initial utilization review denial. Now, the current rule reads that if the dispute is only in regards to a formulary dispute, it's 10 days. Now, what's a formulary dispute? Well, in the last couple of years, the Workers' Comp Appeals Board now has a formulary for medications. So if it's a dispute solely over whether a medication is on the formulary or not on the formulary, then that would be 10 days. The required medical records. Now, when I say required for the insurance company, again, only 6 months worth are required. They must be provided by the claims administrator to Maximus within 15 calendar days of the date designated on the mailed notification or within 12 days of the date of electronic notification. Now these are the time frames, even though there's a labor code out there that says 10 days. It's 15 days if you get a written notification and 12 days for an electronic notification. Now, how does this come? We get a letter from Maximus. If you're not represented, you're going to get the letter from Maximus. It's going to say, as an injured worker, you can go ahead and submit medical records, and here's how to submit them. The same letter goes to the insurance company. Now, I would point out that it's required for the insurance company to send medicals, but only 6 months, but it's required that they do. Now, both the treating doctor and the applicant have the right to submit medical records as well. Now, it's not required, but it's from our office, we do it. I mean, it's required in my office for us to submit them, but it's not required that you as an unrepresented injured worker submit them or that any other attorney out there submit them. That's not a requirement. Now, how long does IMR have? And this is a question we get all the time. We got a lot at the beginning when IMR first came out, because when we first came out, it was 6 months, 8 months, 9 months before we even started getting these back. And the code says they've got 30 days. Well, those cases went to trial and they've come back saying the 30 days from Maximus is just a guideline. And if Maximus does not follow the guideline, there's no repercussion. So there's nothing that we can get as an applicant attorney or as an injured worker as a remedy for the IMRs coming out late. All right, so what does it look like when we get an IMR overturn? So an IMR overturn, again, is going to be something was denied by utilization review, probably denied on appeal. And now this is our third chance to get it approved. So here's an example of an overturn. And what do we look for in here? Is this word right in the center of the page that says overturn. First place my eyes go every time I look at a Maximus decision. So when we get an overturn, we look at what was up here. In this case, it was a medication. The insurance company has 5 days from when they get this to go ahead and authorize that medication. There's no appeal that the insurance company can do to the independent medical review decision. Now, here's what you'll get more often than not, because 90% of the time, the utilization reviews are upheld. And here I've highlighted the word for you, uphold, and the different things that have been requested. In this case, I'm going to kind of go over what's on here and what we should look for and what you can talk to the doctor about as an injured worker to try to get this approved, because it's not the end of the road in most cases. So here, it says MRI to the left shoulder and MRI to the lumbar spine are the two things which Maximus agreed were properly denied by the utilization review company. So here is the explanation from Maximus on why the MRI of the left shoulder is not medically necessary and appropriate. And I've highlighted some things on here. So here it says most acute tears without significant weakness should wait approximately 2 weeks prior to imaging, as some injured workers with acute pain and limited range of motion resolve clinically. Those with subacute or chronic pain should generally have failed non-operative treatment, including NSAIDs, non-steroidal anti-inflammatory medications, exercise, and injections. Based upon the medical documentation presently available for review, the above noted reference does not support a medical necessity for this specific request. Exhaustion of prior use of conservative treatment was not fully established to warrant the specific request. No mention of trialed and failed NSAID, exercise, and injection. So this is our key right here, is the fact that it said no mention of trialed and failed NSAID, exercise, and injection to warrant specific request. So this is where it's time for a conversation with the doctor, for the injured worker and the doctor. And the reason for the conversation is you may look at this and say, doctor, I was injured in 2001. I've had NSAIDs for 15 years. I've had injections that are longer than a laundry list. And then, so what can happen is the doctor can go ahead and resubmit this request. And we'll go over this later, but this is where the doctor can resubmit the request as a change in material facts. Because the reason why this is a change in material facts where the doctor can submit a new RFA is they did not have the facts of failed medication, exercise, and injection. Now, on the other hand, if you have not had this yet, if you have not had the exercise, you've not had the medication, you've not had the injection, then it would be advisable for your client, for your doctor to go ahead and try these things. If they work, you may not need the MRI. If they don't work, they can proceed by they can proceed to request it again with a material and change of facts if it's within the 12 years. All right, so here is the other part in the same denial was the MRI of the lumbar spine is not medically necessary and appropriate. The submitted clinical documentation does not provide any data to indicate, again, the same thing. The injured worker already showed failure in other treatment modalities, include NSAIDs, aerobic exercise, directional preference exercises to warrant this specific request. As such, an MRI is not medically necessary. So this is where you take this, you go talk to your doctor, and you say, have these already been done? Now, from our office's perspective, what we do is we're going to mail this to the doctor. We're going to mail this to the doctor with a letter that says, please look on pages 3 and 4 of the attached IMR decision by Maximus. If you feel that the criteria have been made, we ask you submit a new RFA. So we do mail this on every one of these denials to the doctor. Now, that being said, it is very important you talk to your doctor about this because they get a lot of mail. They get a lot of mail from us. They get a lot of mail from other attorneys. They likely don't have time to read every piece of mail, but your mail probably will end up in your folder. And that would be a good time to talk to your doctor as well. I believe these are also emailed out to everybody. We have an email address on file, so you should get a copy as well of what we're writing to the doctor on these. If you're not getting it, the emails on this, please let us know, and we'll make sure that we have all your email addresses up to date. Now, how long is a UR denial good for? Again, utilization review. And a lot of doctors are going to tell you this. They know this date well. The rule of this is that the denial is valid for 12 months for requests by the same doctor unless there's a material change in facts. The doctor is going to tell you the MRI was denied. We have to wait until next May, Scott, to go ahead and request this again. Okay? But that's not necessarily true. Okay, it is true in some cases. It's true if there's no material change in facts. So those are two of the things. The two key things here are the same doctor and there's a material change in facts. So maybe your primary treating doctor, the internist or pain management doctor, did request an MRI of the lumbar spine and that was denied, right? Then you went to your spine surgeon who again requested it. Okay, the insurance company can not deny that as a duplicate request because that's a different doctor. Okay. Also, if they waited longer than 12 months, they can't deny it as a duplicate request either. Now, often this is what I keep talking about. After a denial, the doctor can resubmit the request, marking on the form. And when I say the form, I mean the RFA, the request for authorization. that required form that initiates all medical treatment. There's a box that says resubmission, change in material facts. If the reason for the denial is no longer valid, or there are additional facts to support the denial. So, for example, let's say we have this MRI that we're working with, the lumbar MRI, where they say you didn't try the injections, you didn't try the physical therapy, right? Well, now the doctor can resubmit it. They can document either right on the RFA form or with the accompanying medical report that's going to go with it that the applicant's already exhausted the conservative measures, including list of things that are right there in the IMR. Those should be things that are very probable to get your request authorized. Now here, for example, if a medication is denied because the denial reads that there is no documentation of functional improvement with the medication. This is the most common denial we get on pain medication. No documentation of functional improvement. So the doctor can resubmit that same medication. The same medication you've been getting for a year, and you're like, how come they've been authorizing it for a year? All of a sudden they didn't authorize it, right? So then you read the denial, and it says that there's no documentation of functional improvement. Doctor can put in a new request. On that request, the doctor can write, patient reports, while the patient's taking the OxyContin, the functional improvements, great. There's no impairment of ADLs, able to shower himself, use the restroom himself, feed himself. However, without the prescribed medication, the applicant has a tough time bathing without assistance and so forth. And that may be even more than they need to document. They can probably just document an increase in functional improvement. But if they can actually if they can actually document exactly what was increased, that's going to increase your probability of getting it authorized. Another example that we get a lot is surgery. Sometimes the surgery denials will say they're being denied simply because there's no internal or psych clearance. Now, when you read this, and then you go to your doctor, and most doctors, they're going to know why it's denied, and you're going to go to your next appointment. They say, guess what? We're sending you out for an internal clearance and a psych clearance. Make sure your heart's okay, your liver's okay, and that psychologically you go through this particular treatment. Then once those come back, they can go ahead and resubmit it. They don't have to wait 12 months from the date of the denial to resubmit that. Again, also, this is what's missed by the adjusters a lot, and is one of the few, which we'll get to later. There's only a few times now we can go to court. And one of the times is when they don't even send it to utilization review because they say it's already been denied in the last 12 months. But now you're going to a different doctor. Maybe the back surgery was requested by your general primary doctor, and now they're sending you out to a back surgeon. Now, they need to do utilization review for each one of those, and if they refuse to do it, that'll be one of the rare cases we can still go to an expedited trial on these issues. In many cases, the request can be made. Okay, so in many cases, the request can be made again within the 12-month period. So if you do get that as an excuse from a doctor's office or a doctor, it's, as we saw here, it's often not the case. They can usually submit it again with the material change in facts. They just have to document that what that change is. Okay, so what can be done by the applicant or the applicant's attorney to assist in getting treatment approved? So what we do in our office is we attempt to repeal every UR denial we receive. We do both these types of appeals we talked about. We do both the internal appeal and we do the independent medical review application. They're usually done in our office between 1 to 3 days from when we receive the denial from the insurance company. Usually we get these by fax. So in fact, we have people on these utilization review denials, people working at night to do this portion of it, because we try to do them the same evening from when they get in. So in addition, we write a letter to the doctor asking for a rebuttal to the utilization review denial. So we can send it to independent medical review to help to get an overturn of the decision. Now, again, we can't send anything to utilization review. So when we're getting medical reports or we're deciding what to send in, it's only things that we can send in to independent medical review. We cannot send it to utilization review. Those are two separate things. And one of them is the time limits. The time limits on independent medical review are much longer than the utilization review time limits. Now, if the IMR, independent medical review, comes back upholding the decision, we send a copy of that decision to your doctor along with a cover letter asking if they think you can meet the criteria to request a treatment again, a new RFA. And when, from our office, when IMR requests records, these can be provided, and we provide them either by fax, paper, or uploading. And so we upload all the records we have, but as an applicant attorney or as an unrepresented applicant, you also have the right to send medicals to Maximus. And if you're an attorney's office, they do have an online portal. If you're paperless, you can just scan everything in. And if you already have everything scanned in, it's a very easy process. It's actually one of the things that forced us on our older cases that we hadn't scanned everything in, all the medicals, to have them all scanned in so we can submit it. Even if your case is 20 years old, rest assured, every time you get a denial from Maximus, that they're getting all of your records. Now, what can the doctor do? Now, the doctor can help you by writing rebuttal reports to the UR denials, utilization review denials, to be submitted to independent medical review. Because we will submit those when we submit the records if we get them in before it's due. Now, when treatment is denied, the doctor can also review the denials to determine what can be done to get the treatment approved, just like I showed you on the IMRs today. Most of them, I won't say all of them, but I would say 75 to 80% of the IMR decisions will give you the roadmap on how to get that treatment approved. Unfortunately, as an attorney or as an injured worker, we can't do it ourselves. It needs to be in a doctor's report. We can't write the material change in facts RFA. We can't write in that all this stuff has been finished already, but that is something that your doctor can do. So again, the doctor can resubmit an RFA with a material change in facts that addresses the shortfall of the prior request. Now, what can the applicant do? The applicant, in this applicant, I mean injured worker. The injured worker, it's helpful to read and understand the denials. When you see your doctor, this is the time. This is the time to give them the information you need. And whether you see a doctor or a physician's assistant or a nurse practitioner, all of them will take the information. And you get once every 4 to 6 weeks, you get to see them face to face. We can send them letters. We can even try to call them. But really, it's when they see you, they have your file open, and when they're working with you. So when you can explain this and go over it, or ask them to explain to you, why is your lumbar spine MRI being approved when it says there's no documentation of NSAIDs and you took the NSAIDs? There's no documentation of physical therapy and you had the physical therapy, or injections and you had them. Ask the doctor to just include those in the report and to request it again. Now, the applicant can also discuss with the doctor alternative treatments if the doctor does not think the treatment can be approved. Okay, the doctor may say that, he understands that this medication works for many people. However, it's no longer on the formulary for workers' comp medications, right? So then ask him, if this is, doctor, we've tried this for 3 months. They keep saying it's either not on the formulary, it looks like it's not going to be approved. What other medications can I take? Is there some other kind of treatment that I can have? And sometimes you may go in there and say, doctor, I had 12 physical therapy visits. You say I should try 6 or 12 more. What else can I have? And the doctor looks at you and says, well, the next step after these physical therapies, surgery. So In those cases, the doctor may be able to go ahead and do the request for a surgical consult, and we may be able to convince the adjuster, let you try 6 more physical therapies before you go through a back fusion. So sometimes those alternative treatments, when they're very costly, it may encourage the insurance company to try acupuncture or physical therapy or something else that's being denied. So the main thing as an applicant is understand how the process works. Believe it or not, many doctors don't know exactly how the process works. They'll tell you that it's, as far as the request, the RFAs, it's handled by their back office, okay? But knowing what you need and how to explain it to the doctors will be very helpful for you in getting your treatment approved, especially in some cases where you may be assigned a Kaiser doctor who doesn't necessarily do very much workers' comp. You may be assigned, pick a doctor who 5% of their workers comp, or maybe you have an oncologist because you have developed a particular form of cancer that developed in the workplace or was exacerbated or sped up by work, and so we had the cancer to be found industrial. So most oncologists will not have any other workers' comp cases but you, or maybe they have 4 or 5. They don't know the process at all, and we try to explain them. But if you can also know the process, I can tell you it's going to be a big help for you in getting your treatment approved. Okay, so this is what we hear a lot, because in the olden days, when I say olden days, we're looking at pre-2004, and in some cases pre-2014, but many applicants' attorneys would go to expedited trials. We were known. You may talk to a lot of doctors that have treated our clients for years, and they're saying their office always goes to expedited trials and gets these approved. But now that we have utilization review and independent medical review, it's no longer that easy of just filing for an expedited trial. But there are still some cases where we can go to an expedited trial. And I know if people keep asking questions in the question and answer, I'll definitely get to them all as soon as we get through these slides. So when can we go to an expedited trial? We can go to an expedited trial when there was no utilization review done. The doctor did a proper request for authorization, RFA. Insurance company, for some reason, didn't do a utilization review. We can ask for a trial in front of a judge to have your treatment authorized. Number 2, a late utilization review. So usually this is going to be over 14 days of them receiving it. You know, sometimes we can go after 7 days or 5 business days. But usually if they're going to go longer than that, they're going to send out the proper letter that they need to get an extension of the time to 14 days. But if it comes out and the utilization review request was submitted in January and you get the denial in March, give us a call and it'll say, says right on here, they received the request on March 21st. The denial is dated March 3rd. If we can get the proper documentation from the doctor to substantiate the need for the treatment, we can go to a judge to get that approved. Now, this is what we see occasionally, a UR approval, utilization review approval, but the adjuster refuses to authorize. There can be a number of reasons. The adjuster says they think the utilization approval was wrong. The adjuster is disputing a body part, but if they're disputing a body part and they got a utilization review approval, or some cases that say that they need to approve that since they submitted it to UR. So that's another time we can go to an expedited trial. And the last time, which is probably the most common, is the failure of service of the utilization review denial. Well, what does that mean? Well, they need to serve that or give that to your doctor, to you, and to our office, your attorney, if you're represented, or your attorney if you've got a different attorney. If you look on there and say, well, Silberman Lam, you've been my attorney for the last 3 years, but the attorney that I had for the 2 years before that is being listed on this denial. That's going to be a reason why we can go to an expedited trial. Now, I can tell you, usually when we see they're serving the wrong attorney's office, we're going to pick and choose which one we're going to go on, because I guarantee you, the day we go to an expedited trial and point out the reason why we're there, judge and defense attorney, is because you served XYZ law office instead of Silberman and Lam, that'll be the last one they send you. So if you tell me, they denied my 6 acupunctures, it wasn't, it wasn't sent to you, I've already had 12 acupunctures that didn't work, I don't want any more, we're not going to choose that one to go to trial. But, we may wait until your MRI or your surgery or your injection or something that's more important for you. So those are the only limited times we can go to an expedited trial. Now, there is one other that we normally don't go, and that's if there is in the independent medical review what we call a mistaken facts. If you read through the facts, and the facts in the independent medical review refer to a 24-year-old waitress, when you're a 62-year-old construction worker, then we can go to trial, but the only thing we can get after trial is a new independent medical review. So what we would rather do is have your doctor write a new request for authorization and go through that process again, because you'll have much more chance of it getting approved than the chance that we have to send everything back to IMR and you've got to wait the whole process for IMR and submitting records, everything again. All right, so this is what we hear sometimes from our clients who just feel like, throw my hands in the air, what do we do now? We tried everything. The doctor tried everything, it won't get approved. They're saying that my treatment's experimental and they're not going to approve it, or the current medication's not on the formulary, or it's not eligible for my type of injury. So for medication, if you're covered by other insurance and you're told by something is not being covered by workers' comp, you should always be able to go to your other insurance. If you have group health insurance or Obamacare, it's what we call coverage for any type of injury. Now, if they feel they shouldn't pay for it, they have the right to subrogate or bill back your workers' comp insurance company. But when you have a prescription from your doctor, I always tell my clients, put your health first. So get that prescription filled. If it's being denied and it's going to take us months to get it approved, I often get from my clients, well, it's the principle of the matter. I want workers' comp to pay. So if you're not going to be able to function without your medications, you should put your health first. The principle of the matter will be, we'll continue to fight it, and probably your insurance company is going to try to bill them after your case is over. But always put your health first. Now remember, okay, let's see. It's your doctor decides what treatment you need. Workers' comp only determines if it's something that will be covered under workers' compensation or not. So workers' compensation, we have the formulary, which is the medications they cover. We have the medical treatment utilization schedule. So it's limited medical treatment, much more limited than your PPO or your HMO that you have your health insurance with. So you can get your treatment somewhere else if we've tried everything, or if it's something that you need right away. You can also discuss alternative options with your doctor for treatment. What do they think can get approved? That's something that may be important and maybe more helpful for you than not getting any treatment at all. And if all else fails, if you've had the same doctor for a long time and the doctor is telling you there's nothing else I can do, and you feel that you go talk to the doctor and say, look, the lumbar MRI, we can get it. We just have to document X, Y, and Z. And the doctor is saying, well, we wait 12 months. That's not something that we do. Then feel free to talk to us, or if you represent yourself, another attorney, about getting another doctor. I would, say that we will probably have a good opinion on this or not. If the doctor has, a good record, or with, in general, with appeals and so forth, then it may be more the facts of your case. But sometimes you get to that point where the doctor is fed up as well. Okay, so I'm now going to go through. Feel free to type in whatever questions and answers whatever questions. I'll try to give you the answers, and I'm just going to go ahead and read them here one by one, and I haven't prepared for any of these, so we'll see. So okay, after treatment determined necessary by UR or IMR, you said adjuster has 5 days to authorize. Okay, so it's after, I believe the code says after the IMR overturn, they're supposed to authorize within 5 days. Now, do adjusters actually send a separate authorization letter or just rely on the UR IMR document? So in most cases we see the adjuster will send an authorization letter and they'll attach to it the maximus. If it's IMR, they'll attach to it the maximus determination. Now for utilization review, most doctors will accept the utilization review as authorization itself. I don't believe the adjusters mainly do the UR, but for the independent medical review, they usually do send that. So yeah, so the follow-up question was, I thought UR letter was sufficient. So I believe the UR letter is sufficient, but I believe the IMR is not. Okay, so here's one that the law office requested, independent medical review on February 27th, 2020. We've not yet received a response. Is this a normal time frame? So I would say that yes, 2 to 3 months is probably a normal time frame, because what happens in the process is this. Usually we go ahead and request it. Somewhere between 15 and 30 days later, we get a request from medical records from Maximus. We submit that. So let's say it took Maximus 30 days to get us the request for medical records. Then 15 days later, they're going to close the window, and then they're going to assign it to a doctor to go ahead and get that done. So I would say somewhere between 2 to 3 months is a normal time frame for most IMRs. Now, for ones that were requested last year, then if it's with our office, let us know and we can check on them. They should have been decided by now. Let's see. Okay, so here's another one. I'm sure you've heard the term papered to death. Do you feel that sending all records to IMR is a potential problem that causes reluctance to overturn a denial? So possibly. Now, my understanding is IMR, they get everything. We send it by, they PDF everything. They're searching for keywords. They run these records through computer programs to see what's done and what's not. If someone has 20 years of records, we're not going to pick and choose things out. We don't want to miss anything. So I think the best way, if possible, and I know for a lot of law offices that are currently still all paper, it's not something that's practical. We're lucky in that we have, converted to a digital environment to do that. But I think it's better to overturn them. To overkill them with records. And that's actually what we told them the 2 times they called us. Well, if we're giving you too many records, then maybe you should just authorize it. But probably their doctors are complaining because the doctors get a fixed fee for each one that they do. All right, the next question says, when uploading medical records to independent medical review, do you upload one big PDF of the entire medical file or all the individual reports separately? That is a very good question, and I will take down your name and get back to you on that. I don't know off the top of my head, but if any of my staff knows and is watching, if they can answer it with a question, that would be great. Oh wait, hold on. Maybe I'm getting a lifeline right here. Hello? You have an answer to my question? Got it. Thank you. All right. So I have the answer. So we submit 2 files. One has our letter to them, and the other is one combined file of all the medicals. All right. Next question. If submitted to UR and UR authorizes but body part is denied, so insurance company wants to challenge, what's the chance of success at trial? So there's cases that say, and I'll try to get them for you, if you submit it to UR, then you waive the body part denial. Also, what about an insurance company who does not have UR? Can RFA, which wouldn't get submitted to UR because there is no UR in place, result in expedited right away? Anything else to consider? So it's very interesting because only doctor can deny medical treatment, an adjuster can authorize it. So when I go over this utilization review, independent medical review procedure, one thing that's important to know is if you are in what's called a carve-out, you're not in front of the Workers' Compensation Appeals Board, maybe you're with a union that has a separate agreement. We deal with a number of those cases. A lot of times we don't have the IMR process. Some of them don't even have UR. But if we're dealing with an out-of-state insurance company with no UR, you've got a problem. If you're a defense attorney, which is obviously who asked this question, my recommendation is introduce them to one of these UR companies. If not, they're going to basically have to authorize all the treatment. Now, in theory, if we do go to an expedited, then we do have to prove the necessity of that treatment, but you don't get a rebuttal. So I need my doctor to be able to lay out why that treatment is necessary. Obviously, if somebody gets a clean MRI and a doctor wants to do a 4-level back fusion, then there's a good chance the judge isn't going to believe it unless they can cite medical literature that shows that. But really, there are also cases out there that go, if you deny treatment without utilization review, it's pretty much an automatic penalty. And it's also for the insurance company, if you look up I think it's for not having a utilization review program in place, there might be a huge audit penalty. I know that we have some auditors on here, but I don't have them right in front of me, but it could be as high as a $50,000 penalty for them not having utilization review. That wouldn't go to the applicant, that would go to the Department of Insurance to help line their pockets. Okay, so let's see, hello. So one time I was told by a doctor at my primary doctor's office, not a workers' comp doctor, because I have an active work comp case on my back, she could not evaluate or treat. So was that wrong? She said I can only be seen by my workers' comp doctor. However, I couldn't get in to see him right away for the pain. Okay, so my understanding is that the doctor should see you. I can tell you most non-workers' comp doctors don't want to see you. They don't want to see you because they don't want me in their office taking their deposition. They don't want to deal with anyone subpoenaing their records. But it should be something that's covered by your insurance. But we'll always tell our clients, you need to see somebody right away. Then go to an urgent care or an emergency room. When they ask for the insurance information, you're going to bring with you the adjuster's information, phone number, and your claim number, and that's what you can give them. And if you do have normal health insurance, you can give them that as a secondary. Always give your workers' comp as primary. And if they have 2 forms of insurance, they're going to have no problem treating you. But even if you don't, even if you have no insurance at all, no Medi-Cal, no Medicare, no health insurance at all, and you do go to the ER or urgent care, make sure you give them your workers' comp information. Okay, so this person asks, I'm not a surgery candidate, but I have a pinched nerve and wear and tear. How long do I have to do treatment before closing my case? I got injured 2 years ago. So it's really, once your doctor, it's something to ask your doctors. And I'm going to do one of this in this series of webinars we're going to do. One of us is going to do, how does a case, workers' comp case, end, where we'll address a lot of these questions. But if your doctor releases you and does a final report, that's usually the time that we can discuss settlement of your case with the defense or looking to go to a trial. Okay, can an IMR request be delayed if the employer is denying the case? So if your case is denied, then utilization review and independent medical review is on hold. In most cases, you're going to get letters from the adjuster saying they're deferring utilization review on the doctor's request. Now they have, on a denied case, not a denied body part, but a denied case, they have the option to put it through utilization review as a denied case and wait for later, or they can wait till the case is accepted. Now, after the case is accepted, it's a very interesting exception, and that I believe they have 60 days from the day that it is accepted to process all the old RFAs they've deferred in the case. So it's one loophole that applicants' attorneys use to get things approved on a denied case is wait the 60 days after it's accepted and then go to an expedited and gather all your old requests for treatment that are still valid. Obviously, if it's for an x-ray you've already had, that won't be important anymore, but that's another way we can go to an expedited hearing. All right, so let's see. So this is a follow-up on the question in regards to going to an expedited hearing on an insurance company that doesn't have a utilization review plan. And it says if we go to an expedited, we don't get a rebuttal, right? Because the only thing for utilization that review for a request for an RFA that can be used for rebuttal by an insurance company is a timely utilization review denial. So even if we go to an expedited and you have a utilization review denial, but it was a month late, you don't get to use that as an exhibit. Can we offer QME reports or other factual evidence? I don't believe you're entitled to. I don't believe you are entitled to that. All right, so here's another question. I'm retired with CalPERS disability, IDR pension, and I'm currently receiving now. Will the state of California subsequent injury benefits trust fund affect my continued payments or change the amount for my IDR pension from CalPERS? It's a very interesting question because it's a segue into me saying that next week I'm going to do a webinar on subsequent injuries benefit trust fund. But as a teaser, I'll go ahead and answer this. And the answer is basically no, it's not going to affect your pension. On the other hand, will your pension affect your subsequent injuries benefits trust fund benefits? Probably. I'll explain all of those offsets and credits next week. If I do get approved for my claim with subsequent injury benefit trust fund, is that another separate pension disability income I can receive from the state of California as well? And yes. So while there may be some offsets for the other pension you receive, it may completely offset it in some cases, but in most cases, it may just reduce the amount you get from subsequent injuries benefit trust fund. But yes, you can get subsequent injury benefit trust fund benefits and another disability pension. All right. Can a QME request for MRIs be denied when the results are needed for his supplemental report? So this is a reason for an expedited hearing. So we didn't talk about QMEs here. I'm actually in another segue. In 2 weeks, we're planning on doing something about QMEs and what for an applicant to expect when they go into a QME exam, what happens in the exam. And I'm hoping to have a QME doctor, myself, a defense attorney, and an injured worker who maybe have gone to a number of QME examinations to go over their experiences. But requests for diagnostic tests by a QME are not subject to utilization review, and we can go direct to an expedited hearing for that. All right, this next question just says, hi, Scott. So if you actually have a question and you wrote, hi, Scott, feel free to add to your question. Next one. Okay, so this is actually a question that's coming in from a Department of Insurance auditor, so I better make sure I get this one right. Does the company have to inform you that you're entitled to a second opinion and that it has to be with a different doctor? So my understanding is no, they do not have to give that information about a second opinion after a denial, but it's possible that I'm wrong with that. All right, so it looks like, does anyone else have any questions or anything else they would want me to comment on, feel free to type it in now, because I'm going to go ahead and wrap it up here. But I just wanted to, you know, as okay, so I have another question here, which I'll kind of summarize, that a person has a constant ringing in their ears. They've got migraines affecting their vision. They've received a pacemaker, and so far the only doctors that they've been authorized to see is a neurologist and a psychologist. So in this case, you have yet to see a cardiologist because it's not part of the workers' compensation case. So in cases like this, where there's not an accepted body part, it's often that we're going to go to a QME, or a qualified medical examiner, in that area. And that'll be one of the things that I will try to touch on a lot at the QME webinar that we give. And that's when we can get multiple QME panels, and when the doctors that are already assigned don't have not addressed everything. So just to wrap up, again, my name is Scott Silberman. Sorry for my casual appearance here in these COVID-19 days, where we're doing things like webinars and other things to keep in touch with everybody. I hope everybody stays safe. Another announcement today for people that didn't know is that as far as coronavirus or COVID-19, the governor did enact an emergency declaration today that made it what's called a presumption for essential workers, that if you contract COVID-19, that it's presumed you got it at work and you're entitled to workers' compensation benefits. I know that we've been dealing with a lot of nurses and things who have contracted this, and their employers and insurance companies are denying that they could prove that it occurred at work. Well, with this presumption, it should make it much easier to get benefits for those people that unfortunately, you know, are working to protect all of us and end up coming down with this horrible virus. I think that's it. Thank you all very much. Feel free. You can always email me questions directly at Scott, SCOTT, @silbermanlam.com. I'll try to get back to them as quickly as possible. And if you would like a copy of this presentation emailed to you, go ahead and hopefully I did this correctly, and it will work, and I can email you a copy of this webinar. Thank you for bearing through my first webinar, and I hope to see some of you next week.